actually. Slides are in German. Why is that? Because I will put a lot of legislative text, or not a lot, but some of the what I present is citations from the law, and there is no official English translation. So I present them in German, but I will talk in English. So and there is not a lot of text itself, so it shouldn't be a problem for you, huh? You should know that what I present here is our interpretation of the law, and authorities don't agree necessarily 100%, especially ethics committees don't agree among each other. And we know that ethics committees, at least some for certain projects, don't agree with our view on the issue. So this is important to know. Huh? So anonymized data, what is it? Anonymized research data, what is it? And what does it mean in practice? And before I explain to you what it is or what it not is, I can already tell you that in practice, at least if you are working in projects that deals with persons, that collects data from persons, from individuals, you will rarely be faced with anonymous data actually. So based on persons or coming from persons, I'm not talking about aggregate data that we often see in public health service research or epidemiological research. I'm talking about person-based data. So it comes from individuals, and the data is on the individual level. It's also important that when it comes to health research, there's often a misunderstanding that we must have anonymized data and that we are only allowed to share anonymized data or use anonymized data. And that's obviously not the case. I mean, it's not possible anyways, for example, in a clinical trial. But also for data sharing, it's not a prerequisite. It all depends on the consent that the participants gave. So this is also important. On the other hand, even though we're it doesn't mean that we can be lazy, and I think I explained that in my previous talk why that is. Huh? And we need to make sure that even though we are allowed to have non-anonymized data and work with anonymized data, it doesn't mean that we can be lazy. Huh? There. Now, the relevant regulation again is the Human Research Act and the related ordinances, but also the text that comes, the official documents that come with those. So that's the Botschaft. There is no English translation of this text. There's probably a official French translation of the Botschaft. Not sure how it's called in French. And we have the erläuternde Bericht über die Verordnung. So there is texts that are published by the Federal Office of Public Health that explain the ordinance and the act and what is written in there. And this is important sometimes to understand what is intended by the ordinance. Huh? Everything that is not regulated there, but in data protection laws, for example, being employed by the University of Bern, the cantonal data protection law applies to what I'm doing also. So everything that is not regulated in the Human Research Act, we need to make sure that we that we also follow the data protection laws. And I think in your projects, because you're also cantonal, the data protection law from the canton of Bern applies. Let's have a look with definitions. And the law, Human Research Act in Article 3, differentiates, and I'm coming to the coded data after I talk about anonymized data. The Human Research Act distinguishes Personendaten, so personal data, from anonymized data. And personal data means that we can identify a person from this data, an individual. Whereas an anonymized data means individuals can not or only with disproportionate effort, how it's called in the unofficial translation, can only be identified with this disproportional effort, the specific person. This is exactly the same definition as it is written in the data protection laws, and is also how it's defined in the European regulation, in the General Data Protection Regulation. Now, the Bericht provides a little bit more information on this aspect. And here, the last sentence is especially important, and I want to look into that in the next slide a little bit more into deeper. So when we have anonymized data, then we cannot reconstruct anything. The interesting thing is, even though I just give you one story, we had a project, an academic project, but it concerned a device of a company. And then the company asked whether they can have access to the data for submission to in the US to the FDA, for the Drug Administration. And then we said, yeah, it's difficult and so on. And there's issues with privacy. And then they said, it's not a problem. We only want anonymized data. And then we said, yeah, okay. Then we agreed with the sponsor, with the investigators. And then we said, okay, we provide only anonymized data. And then we sent this data. And then the company, and it is a large company, so there is a lot of good people that are better than me, myself, and anybody else working at CTU. And then they said, we identified issues in 20 of those records, or 10 records. Can you clarify those? And then we were really surprised, because it's clear if we provide anonymized data, there is no possibility to clarify anything anymore, because we are not able to reconstruct anything. But you see already that even though people who are experienced or often work with this, sometimes in practice it happens that they fall into the trap, I'd say. Okay. This is why we need to be very careful when we talk about anonymized data. So what is, here's an example. We have a study, for example, in Basel. Data was collected, and when we, as I mentioned, we always, when we collect data in a study, in a project, in a prospective study, we need to identify the individual, because we will need to follow this person. And for this purpose, they, in Basel, they had a patient participant log with which they could link the study data and the individual names. Here, Studien-ID. So that's the link between the participant log and the study data. Now, a research group in Bern asks the Basel group, can we have this data? We want to do a further use project. We want to do additional analysis. And the Basel people agreed, yeah, this seems to be a good idea. Let's do that. But they realized that it's good practice to replace the original study ID by a random number. And they did that. And obviously, the identifying information remains in Basel, no access for the Bern people. Now, the question is now, do they have now anonymized data? Does the Bern group now receive anonymized data? And it doesn't fall under the Human Research Act. Obviously not, no? Because in all cases that we are aware, this the amount of data that is in the study database in every project that we are aware of, at least when it comes to clinical research, health research, the amount of data allows to identify information, the combination of this data. Even though the study ID is replaced with a random number, we have so much information about the individual that is not a problem to link back and identify a person. So this is this requirement that the reconstruction is not possible is only a theoretical one for health research from my point of view, but not a practical one. So the Human Research Act is fully applicable, and the Bern Group needs to submit a further use project to the ethics committee. This also applies even in the unlikely case that the participant log is destroyed completely, and even the Basel Group doesn't have access to this participant list. Now, the Human Research Act not only discusses anonymized data, but also discusses the aspect of anonymously collected data. And sometimes there is the question whether a project collects data anonymously. So here an example, a made-up example. Obviously, we are doing interviews with football players from Primera División in Spain in this very simple questionnaire, and we are interviewing this player here. And this just should show you that collecting data anonymously is very difficult if you are dealing with patients, because you always know who you have in front of you, usually. So it's clear that if we collect this data from this player, Lionel Messi, that this is not anonymously collected data, even though in the questionnaire itself, there is no directly identifying information collected, but the process of collecting this data is obviously not anonymous. This also applies to at least the manual extraction of data from patient chart, because there we also have, we're accessing this patient chart, so we see the name. So it's even though the questionnaire is not collecting directly identifying information and might be considered anonymized data with all the prerequisites I mentioned earlier, the process itself, the collection itself, is not anonymized and therefore falls under the scope of the Human Research Act. Now, again, closing the loop to what I said beforehand, is this anonymized? So now we have collected this data, not in an anonymized fashion, but we haven't recorded any identifying information. We haven't recorded the name Lionel Messi in our data set. Again, the question remains, is this anonymized data? Just closing the loop again, how easy it is to reconstruct and identify individuals. Only two data points here are sufficient to identify an individual in this data set. So what do we need to do? We not only need to look into each individual data point, and I'll come to that in a second, but we need to check each individual whether each individual variable is directly identifying or allows reconstruction or identification, but also the whole data. And we need to do that. And this is not so easy, actually, and very time consuming, depending on the amount of data that we have. So in practice, we at CTU, at least, we rarely think there is anonymized data, but we We don't go that route. We don't expect data to be anonymized. So it's very difficult. Here again, a little bit what you would need to do if you think you want to anonymize data. Each individual variable needs to be classified. Is it directly in your data set? Is it directly identifying, indirectly identifying, or unproblematic? Then you need to, for each variable that you identified as being a problem, you need to define what you do with this. Either you delete it from the data set or you manipulate it. For example, you round numbers or you aggregate. Then you need to program those manipulation, this data preparation steps. You need to make a quality control. And if the data set that that you now have, that you think is anonymized, you would again need to recheck. And maybe you need to go back again and do this whole thing again. So truly anonymizing is not so easy. And especially considering the computer power that we have. Now, the thing is, the future will bring different things. And the good thing is, if you consider a data set anonymized and you have some proof, you check that very carefully, it's only, you need to prove it only for that moment in time. You don't need to be sure that this data set can be considered anonymized also in 5 years. Wouldn't be possible, and it's very likely not considered to be anonymized in 5 years. That's what we know of, basically, that it will be not anonymized, cannot be considered anonymized in 5 years. But that's also not required by the Human Research Act. So it's only at the time point when you do the assessment that you need to make sure that your assessment says it's anonymized. Now, we also have this concept of coded data. Also, besides the personal data and the anonymized data, the Human Research Act also has this concept of coded data. And again, very rarely can we be sure, or do we have coded data when it comes to research? And this concept of coded data is even more complicated than this concept of anonymization. Again, it's not needed that we have coded data in the legal sense, in the sense of the definition by the Human Research Act. And what I'm talking about now in the next 8 minutes or so is really about this legal concept, not the technical concept of pseudonymization or coding, but coded data as a given term mentioned in the Human Research Act. Again, the regulations, you can have the slides, it's not a problem. Afterwards, here are the relevant regulations. In principle, this aspect of coded data, or whether you have coded data or not, is only relevant for further use projects. So projects, reuse of data. But in prospective or studies or clinical trials, you will never have coded data, because there you clearly have personal data according to the Act. The Act itself considers the terms coded or pseudonymization interchangeable. The German Botschaft talks about Verschlüsselung, Pseudonymisierung, Codierung. They are all the same for the purpose of the Human Research Act. When we look up the glossar of the data protection officer, the Federal Data Protection Officer, we see more explanations there. And the term pseudonymization itself is a technical one and relates to the separation of the identifying information with the rest of the data that we have. And the pseudonym is the non-speaking identifier, and we will see an example. And the key is the secret element with which we can decode or encode our data, here described as text. We will see an example. And the definition talks about coded data. The unofficial English translation says coded data. Coded data is data which is linked to a specific person via a key. And Article 26 of the Human Research Ordinance discusses the aspect of coding, how it's called. No? And it says data can be considered correctly coded if for the person who has no access to the key, or simplified, who looks at the data looks anonymized. That's the definition of Verschlüsselung or coded data. Now, as we will see, this requirement is not enough to consider data coded. So pseudonymization itself does not make your data coded data, or encoding your data does not make your data coded data according to the Human Research Act. One aspect relates to this requirement that I just mentioned for the person who looks at your data or who has no access to the data, to the key. The data is looks like anonymized. I mentioned a few minutes ago that this is nearly impossible for health-related data collection, at least in our experience. But there is additional aspects to that, why we don't think coded data is feasible. Again, we're coming back to our example that I mentioned, this Basel burn thing, the Basel study, where we collected the data and have a participant log. So we have our pseudonym. There's a pseudonym here, the study ID. So we have an identifier, a non-speaking identifier numbered. It's not identifying. Then we have the key. So the participant log as a whole is the key. And then we have that allows us to decode this data basically and link the people. Now, the thing is, I mentioned already this requirement, the Article 26 is not sufficient, or this excerpt that I showed, because an additional thing is written in paragraph 2 of Article 26, that the control of the key needs to be separated from anybody who is involved in the project. So we need to ensure that the key that allows this decoding, this linkage, is not under control of anybody in a research project. So no study nurse, no study coordinator, no statistician, no data manager, no investigator, no project leader, nobody has access to that key. And nobody who supervises, and there can also be nobody like a secretary cannot have control of the key. Okay, so it's non-trivial actually to find a person who controls the key. And although not part of the official definition, Article 27 sets an additional requirement to such data, and sets an additional requirement under that conditions when we can consider data to be coded data, because Article 27 describes the conditions under which we are allowed to use the key. And using the key is only allowed for information purposes and other special aspects, but clearly not related to do any queries, data quality, clarification, or data issues. The example I mentioned previously with the company, all this is not a condition under which we are allowed to use the key. So we need to have a regulation in place or standard operating procedure in place that explains and regulates when the key can be applied. And this regulation or this standard operating procedure needs to be in line with this Article 27. So key must be really separated. And again, the rest of the data doesn't allow reconstructing individuals. Just reminding you of the start of the talk. So the question is, why do we bother about coded data? There's really only one reason why we want to have coded data according to the Human Research Act, and that's because there is a small simplification regarding information and consent. And this is described in Article 32, but it's actually only a very small simplification. So the rationale is actually very small or limited for having coded data. And there we don't see a good reason to have an ambition to have coded data. But going into detail there, again, just a reminder that this doesn't mean that we can be lazy. You know? Access to this identifying information needs to be regulated. And again, we're having data sets with pseudonyms because we usually don't store directly in our databases, in our research data, the identifying information. We separate it, like the Basel example just showed you. But this doesn't mean that we have coded data according to the Human Research Act. With this, I'm finished.